Hello, my name is Stuart, and I will be talking to you today about records, policies for handling, storage, and disposal of these records. I will be talking to you today about the rules in Oregon and how those rules differ in the state of Washington. We'll talk briefly about the ACA Code of Ethics and what that adds to the rules, and briefly touch on HIPAA and how that relates to records. So, starting out on the OAR, it says that you must maintain legible records on clients. So, every client that you see, you have to keep paper records or electronic records on them. And in these records, you must include, at a minimum, a formal or informal assessment of the client, counseling goals or objectives that you're going to work on with them, and progress notes of therapy and counseling sessions. You need to keep these records in a safe, easy to access for you, not for other people, location, and you need to notify the board if the records have been destroyed or lost. You are required to keep these counseling records for at least 7 years in the state of Oregon, 7 years from the time of the last session with your client. Continuing on with the Oregon rules, section 100, remember when you did your informal consent in your disclosure statement, we all did that at the beginning of the semester, their records, the client records, are all confidential, and there are those exceptions to the confidentiality agreement, but other than that, everything that you have that is made up in the client record is confidential. Excuse me. The client should be informed about how long their records are going to be kept. Anytime you do audio or video recording, you need to let them know, and they need to sign an informed consent about that. Same thing goes with discussing any part of their record in supervision, and releasing records to third parties like insurance companies. So if you're getting paid through an insurance company, you need to make sure that your client knows that they will be receiving part of the client record in order to bill you for that, or for them to get billed for that. You must maintain confidentiality in regards to client records even if you stop practicing as a counselor, and you must make arrangements for disposing of those records. So if something happens to you, if you get really ill and can't come into work for a long time, or if you die, hopefully not, but it could happen, I suppose. Or if your practice is closed, you decide to move on to something else other than counseling, those records are still out there and they are still confidential. So you need to make a plan for who's going to take care of those records for you in your absence, and just have a will drawn up for you in what happens to those records. You are required to provide clients with reasonable access to their records, except when the information about the client could result in harm to them. So if a client comes up to you and says, I really want to see my record, but you reasonably feel that it's probably not the best idea, it's okay to show them some of the record and keep some of it from them, as long as you talk about it with them and really process that. What are the differences in Washington? There's pretty much everything's the same. Washington, you still have to keep records, but the only difference is the client's record must only has to be kept for 5 years following the last visit. So in Oregon, you have to keep the record for 7 years. Washington, it's only 5 years. Additional considerations from the ACA: when clients request their records, counselors provide assistance and consultation in interpreting these records. So you can't just give your clients the records and just say good luck and let them figure it out, but you really need to sit down with them and figure out help them figure out what it all means and what's in their record and what's going on with that. When you're destroying client records after 7 years in Oregon and 5 years in Washington, you need to use special discretion and be really deliberate about before you destroy records that may be needed in a court case, such as notes on child abuse or suicide, sexual harassment, or violence. So if you know about your client and it's been after 7 years, but you know that they've been involved in a lawsuit or some kind of court case, you may not want to throw away all of the records pertaining to whatever the issue is that they're arguing about in court. Also, be careful not to disclose confidential information that would identify your client when discussing counseling sessions with your supervisor. So you really want to be intentional about disguising your client as much as possible, and anything that anyone could find out about them or anything from their record you need to keep confidential when you're talking to your colleagues and supervisors. I'm briefly going to touch on HIPAA regulations. The two young women that also presented about HIPAA did a great job, and I probably missed some stuff when it comes to records, but hopefully you'll watch their videos and they can cover it for you. On paper records, you have to keep all paper records under 2 locks. So you need 2 different locking systems. One can be like inside a filing cabinet, and then that needs to be inside your office, which is locked. So locked filing cabinet behind a locked office. That's what HIPAA says that how to keep your files secure. Also, you need to use a shredder when you dispose of these records, or you can also burn them, but it's preferable to use a shredder. And you also need to make sure that your files aren't stored on your copier's memory. So if you're making copies of your client record, you need to make sure that that's not still on your copier if you have one of those really high-tech industrial copiers. When it comes to electronic records, you have basically 2 options with emailing. You can use a HIPAA-compliant email system, and I've listed some good ones there for you. Email Pros and SafetySend. Those are both paid HIPAA-complied email systems, but they work really well. So I would recommend using one of those. Or just have your client fill out an informed consent document saying that they know the risks of using a non-compliant HIPAA email system. If you choose that, you still need to remember that you don't want to send anything, any subject material through email. You can say, I got your email, we'll talk about it in session, and that's pretty much all you need to reply. And electronic charting and billing software. If you want to chart electronically, which I feel like a lot of us will be doing in the future, you need to make sure that you are HIPAA compliant with that as well. So using programs like Theranest and Therapy Notes and Therapy Appointment, those are all really good programs that are all HIPAA compliant, and you won't run into any problems with those. You can store your records and everything in the cloud, so you don't have to worry about running out of space on your computer or your computer crashing or anything like that. And they come with a lot of different handy tools such as appointment reminders, and you can do billing through those programs, and they're just really helpful things to have if you're going to do a lot of electronic things in counseling. That's pretty much it. I've posted some links just about the rules and laws at the bottom of the handout, and yeah, that's pretty much it. Hope you enjoyed it. Thanks.